A logical step for the Council, often after considering an issue like this, is to appoint an independent expert or special rapporteur to examine it further. But many countries, and there were countries that pushed for that and that would support it today, but many countries do not want to appoint a special rapporteur with a mandate to bring human rights norms to bear on climate change. They are very much opposed to that idea. As a result, the Maldives and their allies on the Human Rights Council realized that they had run up against something of a brick wall. They had picked the low-hanging fruit, so to speak, to mix metaphors. I guess they had picked the low-hanging fruit hanging off the brick wall, I don't know. So they had picked the low-hanging fruit in the sense that the Human Rights Council had been willing to recognize that climate change interfered with human rights, but they had run into the brick wall because the Human Rights Council didn't want to accept duties to address it. And this was, to a certain sense, understandable. To see why this is understandable, it's necessary to broaden the focus for a bit, as Bianca Jagger did, to look at human rights and the environment generally. Remember that the core human rights agreements, the two international covenants, don't refer to the environment at all. They were negotiated in the 1950s and early 1960s, just before the dawn of the modern environmental movement. Beginning in the 60s and 70s, that movement transformed the way we think about the environment and our relationship to it, but it just missed the human rights train at the UN level since most of the major UN instruments had already been drafted. Many countries after the 1970s have responded to this increased environmental consciousness by adopting specific environmental rights. Portugal was the first country to do so in 1976, but now more than 90 countries have adopted a constitutional right to a healthy environment. Regional human rights agreements as well have often adopted a right to a healthy environment or a variation on those terms. But again, no global agreement sets out such a right. Nevertheless, it's important to realize, I really can't emphasize this enough, it's very important to realize that despite the absence of a clear right to a healthy environment in international human rights law has increasingly been brought to bear on environmental issues. Over the last 20 years, human rights bodies at the UN and at regional levels have concentrated on greening existing human rights. That is, examining and highlighting how existing human rights to life, health, property, privacy, and many others, how they apply to environmental protection. The OHCHR report was an example of that. It didn't refer in its report on climate change to a right to a healthy environment. Instead, it referred to existing rights, well-recognized rights, such as rights to life and health. The difference at the global or at the more general environmental level is that many of these bodies have also begun to identify specific duties that states have to protect the environment. For example, human rights bodies have repeatedly emphasized that states have duties to ensure that people potentially affected by environmental harm have the right to information about the harm, the right to participate in environmental decision-making that can affect them, and the right to have access for remedies for violations of their rights. There were two big problems, however, the Maldives and its allies found in relying on this jurisprudence to support the application of human rights law to climate change. First, much of this